My name is Tayyibah Suliman. I head up the technology and communication sector. We focus a lot on fintech in terms of advisory and transactional services, and so it's something that I'm particularly passionate about. And today, in terms of navigating this uncertainty that we would have had historically from a regulatory perspective to a more sort of formulaic framework that we have in place, I feel quite fortunate that we've got a lovely mix of lawyers, representation from the regulator, and industry players, which is sometimes unusual because we don't necessarily always have that benefit in terms of a panel. So this afternoon, hopefully, we're going to take a step back and just reflect on how the South African regulatory framework has evolved. And I'm going to start off by inviting each of my panel members to introduce themselves, and then to just tell us something that they are also passionate about so that we know that they're not AI. Do you want to go, Ashlin, first?
Happy to go first. So my name is Ashlin Perumall. I am a partner and head of our technology practice at McKenzie, South Africa, also a law firm. I'm part of the firm's fintech and blockchain group. It's a consultant list of about 80 lawyers across the world who specialize in blockchain, fintech, and related technologies. I'm also a fellow of the World Economic Forum, and I've done a lot of work in the policy space and writing papers for governments to regulate crypto, not just in South Africa, but in other countries as well. Something interesting.
Something you're passionate about, something interesting about yourself is also fine.
I'm passionate about Scotch whiskey. Really passionate about it. I've traveled Scotland in search of bottle collections. I actually have a certificate in Scotch whiskey. It is the only certificate that I've framed, and if I ever decide to get tired of law, that's what I'm doing.
Okay, and no registration with the AA as well?
Not yet.
Thank you. So I'm Johann from Lith. Everybody calls me Joe. I'm a regulatory specialist at the Financial Sector Conduct Authority. I help draft and develop legislation, specifically in respect of fintech. And also I'm the deputy chair of the Crypto Asset Regulatory Working Group, the interagency group where all the financial regulators come together to unpack the landscape. So something about myself and that I'm passionate about is one, tennis, sport. I love it. And also emerging technologies and what challenges it can solve for Africa. So I'm very much passionate about the regional collaboration and opportunities in that respect. Thanks.
Joe, you have to tell us who's your favorite tennis player.
It was Roger Federer, but now Carlos Alcaraz, definitely.
You can stay on the panel.
Hi everyone, so my name is David Porter. I currently work at AltcoinTrader, South Africa's second oldest crypto exchange. I'm a director there and their key individual under the FASE Act. I also founded CASA, the Crypto Asset Association of South Africa. We founded CASA back in 2021, so 4 years old. It now represents over 50 different CASPs across the country. In my previous life, I was a management consultant, then did a stint at Rand Merchant Bank, and then at Thomson Reuters in their finance and risk division. So I've got some experience across the board, and hopefully I'll give you sort of a flavor of not just from the AltcoinTrader perspective, but hopefully a bit of the industry perspective as well.
Great, thanks very much. Joe, I'm going to start with you, not picking on the regulator, I promise, but you have the benefit of having seen the sort of industry in terms of how it's transformed. And perhaps you can give us an overview of that transition to having not had a regulatory framework to the framework that we have now and the observations that you have from a regulatory perspective.
Definitely. So I'll just give you a brief overview of where we are at the moment, because I think everybody would be more interested in where we're going. I think there's a lot of progress that have been made. If you look at 2021, the Intergovernmental FinTech Working Group position paper, and those 25 recommendations and what has been implemented from that period. So obviously from the FSCA side, we brought crypto assets into the regulatory remit with declaring it a financial product and licensing now 98 crypto asset service providers and receiving almost 500 applications. So I think that was an important interim step just to bring in the necessary protections in respect of the harms that we were seeing that can materialize. So it brings in comprehensive regulation in terms of risk management, governance, segregation of funds, as well, and conflict of interest management, which is such important aspects when it comes to crypto assets as well. But that is only from an advice and intermediary perspective, as you know, so it's product agnostic, and it doesn't cover products specifically. It's only the financial services that are provided in terms of crypto assets. So then if you look at what has been done on the AML CFT side, I think there was a lot of progress that's been made with bringing crypto assets in, with having CAS being an accountable institution and amending Schedule 1 with the two items, 12 and 22, and also bringing in Directive 9 that was implemented from 30 April. So that's very important in terms of transparency and collecting that identifying information and passing that on. So those are really important matters that has progressed. We've also seen with the Prudential Authority and the regulatory strategy that was published for 2025 to 2030, that they are also looking at a prudential standard in line with BCBS, just to align with those exposures of crypto assets in terms of the banking financial institutions. And also on the National Payment System Department, I mean, there's a position paper that's waiting to be published probably soon, just to clarify the regulatory treatment or the treatment of payments on a domestic perspective. So I think, you know, there's a lot of work that has been done. Obviously, there are still gaps, and looking at some of the international recommendations like the IOSCO recommendations and the FSB recommendations, there's a responsibility on the regulators as South Africa participates in those international bodies to fill those gaps. And I'm sure we'll speak about it a little bit on this panel as well. So that's just a high-level overview of where we are at the moment. And obviously also from SARS side, they also clarified, you know, that's gains and losses and how it should be reported in terms of income tax.
Thanks, Joe. I mean, that obviously gives us a sense of rigor that has been introduced into our regulatory framework from a South African perspective. What I've seen personally is that it is giving us some credibility in terms of the investments that are made into crypto asset service providers and the like. And there's certainly a greater level of interest in terms of South Africa as a destination for participating in what I think is a really good and well-rounded industry in terms of the participants. But I'm really interested, Ashlin, to hear from you about your observations on regulatory frameworks elsewhere in the world and how that compares to South Africa and what we're seeing in Africa. I mean, we did definitely have some context from other speakers today, but with Baker McKenzie's presence across multiple jurisdictions, what are you actually seeing?
Happy to answer that. I mean, many conversations I've had since the declaration have been crypto assets are now regulated in South Africa. But that's not technically correct because it's actually the activities that are regulated. The assets themselves are not. And that's a deliberate choice, I think, in terms of the approach taken by the South African regulators to regulate the downstream activities, essentially secondary market and not primary market. It's a risk-based and pragmatic approach, but that's not the approach that's taken everywhere. Now, I don't think you can talk about global crypto asset regulation without mentioning MiCA, which is the European equivalent. MiCA is a full stack regulation out of Europe. And what I mean by that is that it regulates everything from issuance all the way down to the costs. So it is every aspect in terms of its regulatory ambit. It is a classification type regulation. We can talk about classifications later, but it is focused on trying to identify where the relevant crypto asset fits into its regime and regulating accordingly. And that has its benefits and downfalls. So the one benefit is obviously a robust regime such as that creates a lot of certainty. And the certainty allows for MiCA passporting, which is essentially across different European jurisdictions. If you're licensed as a CAF, you can operate fairly harmoniously, which is excellent. The downside is obviously a lot of front-end compliance, a lot of work and cost in terms of compliance. So that's Europe in terms of how Europe has unpacked this. I'd say, and that's a standalone regulation. It's not using anything that was in there before. UK is a little bit closer to South Africa in the sense that they've chosen to rely on their current regimes and try and bring in identification of where crypto assets fit into current established regimes with current established regulators. A lot of the regulators very similar to the ones we have in South Africa, and they have a draft piece of legislation out from April this year. I think it's called the crypto asset order, which is looking at stablecoins and other aspects to bring it within the regulatory ambit. So there is some developments happening there where they're moving beyond where we are into regulating specific issuances around stablecoins. If you hop over to over the pond to the US has been a very difficult market for a long time because the focus there has been very much, for example, the SEC and the courts in terms of what is coming out of the courts as opposed to proactive regulation. But with the Genius Act, and that's an act around stablecoins and creating a regime and a framework for stablecoins, that has, again, it's brought a lot of legitimacy to stablecoins globally. I think anyone in this room can say once that act came about, how much volume and how much activity occurred as a result. So there was a network effect from what the US has done. And a lot of that is because what is happening in the US because of the size of venture capital, the size of the startups there, that certainty in that market impacts all of us globally. Zooming back into Africa, Mauritius, I would say, has the most codified MICA-like regime. I think it's because they regulate not just COPs, but also initial token offerings. So they also go a little bit more upstream to the primary market activities. That being said, I would argue that in terms of Africa, we have the most implemented regulatory regime across the board. I think it is very, very rigorous. There's a lot of work that's been done. There's a lot of public-private engagement that's been done, including through the license process. So I think South Africa has taken an extremely pragmatic approach. I think that has been market-driven, and it's one where there's a lot of engagement and where we're a forerunner. Things that I would say down the line, maybe should come onto the radar for us in terms of regulation would be stablecoins, and that needs to be identified as a separate class of asset and requires its own separate thinking in terms of regime, and then also the concept of passporting and whether that is something that within certain African regions is a conversation we can have to allow less friction in terms of crypto assets.
Thanks, Ashlin. I mean, what you talked about in terms of MICA and what we've heard from our clients is that it was a huge burden in terms of compliance. Places like Estonia, historically, which had had quite easy regimes to be able to work in, suddenly became much more rigorous. People were suddenly looking to South Africa to see if we were a less rigorous regime than what you were finding in Europe. Which kind of brings me to you, David. When I think about it, you said to us in your first sort of call that we had was you were in the Wild West, and then now you're in a regulated framework. And I'd be interested to hear your sort of observations in terms of how coming out of an unregulated framework into the current CASP licensing framework has changed your business, what you need to consider, and what that actually means from an industry perspective.
Cool. Thanks, Tayyibah. So, I mean, from AltcoinTrader's perspective, and I think for a lot of the established players in the market, the very first thing that we had to confront was, as Johann said, was crypto asset service providers being defined in the FIC Act or by the FSCA, by the FIC, and then included in Schedule 1 of the FIC Act. So that made us all accountable institutions, and thus we have to do KYC, AML. Now, all the established players in the market had been doing KYC and had fairly robust sort of AML procedures and functions in place for many years before that even happened. So I think that on that first step, the impact was fairly limited. I think where the rubber really hit the road was on the second phase, which was defining, or the FSCA defining crypto assets as a financial product under the FASE Act. Now, that came with it the whole requirement to license, employ or contract certain specific roles, a huge amount of effort in terms of documentation, policies, procedure manuals, the license application. So the cost of compliance when you were thinking of just having a KYC and AML and a FICA onboarding team increased dramatically with that next phase. So, and I'm not just talking maybe about the financial costs. There's also the shadow costs and the opportunity costs. You've got an executive team now that is focusing 70–80% of their time on regulatory compliance instead of innovation, strategy, growth, those kind of things. Hopefully that will sort of tailor back a little bit, and we'll find a happy sort of medium in the process. I think, so the larger players, more established players in the market have been able to weather that storm a little bit better. I think from an industry perspective, and certainly the conversations we had at the Crypto Asset Association, 90% of the conversation is all around compliance and regulation. What I noticed back in the day when this happened 2 or 3 years ago was the first thing was like a scurry for skills. So you imagine being a crypto asset provider startup. You've been founded by maybe a handful of individuals that have a computer science degree, a data science degree, or self-taught coders / developers. Now all of a sudden, the regulation requires that you have something called a key individual and a compliance officer. Now, those people, you can't become that. You can't be recognized by the FSCA as a key individual or compliance officer with a data science degree. You have to have a recognized qualification, NQF level 6, from a recognized or approved institution. And there's a defined list of those kind of things. So we found some of the smaller players in the market it was quite difficult for them to find those skills and employ those people and trust those people in high-level positions at quite a significant cost. And give them a fair amount of control within your organization. So, I mean, that was the first thing I noticed. So they certainly did encounter the same sort of compliance burdens, maybe even to a higher extent than some of the larger players in the room. Finally, I think we definitely saw the conversation in the association be elevated. Where we were in the Wild West, talking about the impending regulations and things like that. We certainly saw the people around the table being far more well-read around regulations, and the conversations around risk management and compliance certainly elevated. So I think the objective of really professionalizing the industry has been met, and you see it every single day when you interact with other CASPs. You see the kind of people that they are employing, and we no longer are operating on the financial fringe, so to speak.
Thanks, Dave. I mean, we see that for new entrants and investors, there's definitely conversations that are taking place about key individuals and people who are appropriately qualified. So I can completely relate to the challenges that smaller players might face. But just to pivot, obviously a big part of what we've talked about, what we've heard lots of people talk about today, is international money transfers, money remittances, and the sort of use case for it is substantially important for South Africa, for Africa, and probably for the rest of the world. In the South African context, though, we've had an interesting case in the way of the Standard Bank ex-con case. I am anticipating that will ultimately land up in the Supreme Court of Appeal, because we will need precedent to be set on that, and certainty for the industry. Ashlin, perhaps because you're the lawyer on the panel, perhaps you can give us a bit of an overview of that case and what it actually, what the courts actually said in that particular judgment.
Thanks, Tayyibah. I mean, briefly in layman terms, like what that judgment was about our exchange control regime. Essentially, South Africa has, under its Currency and Exchanges Act, an exchange control regime, which is an oddity amongst a number of countries around the world. And what that act basically says under Regulation 10(1)(c) is that you cannot export any capital out the country without getting approval from the South African Reserve Bank, the Financial Surveillance Department of the SARB. Now, the definition of capital is quite contended, because the act and the regulations that this comes under were designed for a specific time and with a specific case in mind. And what this case was about was certain assets were frozen, Bitcoin assets which were taken offshore frozen, on the basis of a violation of Section 10(1)(c). And the question that the court had to answer is, do crypto assets amount to capital or not? Now, they relied on a 2011 judgment called Oilwell versus Protech. It was a judgment which had to consider whether intellectual property was capital or not. And in that judgment, it was decided that, and this was an SCA judgment, that the definition of capital is not synonymous with assets. The definition of capital is a very narrow definition. It is focused on financial capital, i.e. something that you could see in legal tender, in fiat money, essentially. And intellectual property did not amount to capital in that case. Equally, in this instance here, in the judgment, the court said, well, it cannot be that a crypto asset, when you look at how it operates, what it is in terms of a notional concept within our legal regime, it cannot be capital following the oil well and Protec case. So that was basically the judgment. What that means is that definitionally, crypto assets do not fall under the exchange control regime, and there shouldn't be a prohibition against taking crypto assets offshore. Now, I think that's the correct judgment, personally. In the IFWG 2021 paper, it was even stated that this was the case, that there would need to be definitional amendments to the regulations to bring crypto assets into the fold, and these amendments never took place. Now, why I say that this is not, even pending a future SCA judgment, I still don't think that this is going to be a long-lived scenario, is because when the oil well case happened for intellectual property 15 months later, the definition was amended and intellectual property was brought under the definition. I anticipate if there is no SCA judgment that that's going to be probably a similar approach. So I think that ultimately this is not going to be a long-lived scenario. I think either this will be brought into the exchange control regime, or there's a wider conversation that needs to happen as this rolls out, whether this is something we should be including, whether it is included in capital or not. I think those in the room who understand how crypto assets work can probably comment on the, I think, ideological problems with considering crypto assets as capital, and some questions we would need to answer before such a definitional amendment is made.
Yeah, at the moment we're quite happy. I mean, I agree with you. I think that was a good judgment. We're happy to tell our clients that, transacting in terms of your crypto assets doesn't necessarily trigger any ex-con regulation, which I think is a good position to be in. But perhaps, Dave, better to hear from you in terms of what's a best case scenario for the industry when it comes to ex-con, and how if you had the benefit of being able to say what you would like the Saab or anybody else to do, it would be this is as good a time as any. Joe will go and tell the Saab.
Thanks. I mean, how much time do we have here? First off the bat, I think getting clarity around exchange control regulations is of paramount importance. When you operate in an environment where there's uncertainty, what you're doing is you're discouraging investment, you're discouraging financial flows cross-border, you're discouraging the innovation behind those things as well, because people are worried that they might be subject to forfeiture of their assets or even penalized. So getting that regulatory clarity is absolutely paramount, and we need it fast. I don't want to stand on my soapbox, but I think, screw it, I'm going to anyway. I understand the challenges that the Reserve Bank and FinServ Department have in in their mandate to stop capital exodus from the country. But when we think about crypto assets and the momentum that has been built by the FinServ, you're seeing that the FinServ want to declare self-custody as externalization of capital. So if I withdraw just over half a Bitcoin into my private hardware wallet, I'm in breach of exchange control regulations. All right? It's more than R1 million. That's my single discretionary allowance that I'm allowed every single year, unless I apply it to SARS and get an FIA, a foreign investment allowance. All right? So that is a significant challenge, that you're discouraging people taking financial control and exercising their own freedom to custody their coins. You're forcing them to custody it with crypto asset service providers. I don't know, are they the next Ponzi scheme? Are they going to be, they don't have the sophistication to understand the mechanism that they've got in place to manage that custody. All right. Then if we think of, electricity costs in South Africa, 99% of the crypto that's entered South Africa hasn't been mined here. Right? You can't mine crypto in South Africa profitably. So every single bit of crypto that's in South Africa, if I can say it like that, represents a capital inflow to begin with. And now we want to regulate or prevent the outflow. Now, when you prevent the outflow, you prevent the inflow, right? And it has significant impact on the industry, all right? So, back to the original question that I've got off my soapbox. What we would love to see as the industry is a complete relaxation of exchange control regulations when it comes to crypto assets. The Exchange Control Act, Ashlin can correct me if I'm wrong, is from 1961. That was when they built the first computer, an IBM, at WITS. And now you're forcing that regulation on a product set and a financial system that was invented in 2009, right? It doesn't really work, and it doesn't fit the mold, and it's not fit for purpose. So I would like it to be completely relaxed. However, I don't think that's realistic. So maybe instead of a best case scenario, a better case scenario would be for the Reserve Bank to create a separate classification specifically designed for crypto assets and certain types of crypto asset transfers and transactions, right, that is probably less restrictive in its interpretation than the 60-year-old act before computers even were around.
Go for it.
It gets scary. It's 1933, which is before dollar was delinked from gold.
Yeah, there you have it, right?
I was, when you said 1933, I was like, yo. But so that gives us a bit of insight in terms of how we would like the sort of regulatory framework from an industry perspective to evolve with some degree of flexibility. And I think often what you will hear from industry players is that they want as many of the barriers to innovation removed. And what you've conveyed, Joe, I think, is that you're actually supportive of that from a regulatory perspective. But perhaps you can tell us a little bit what you think is of critical importance for the FSCA when it comes to CASPs and the future of our regulatory framework in South Africa.
Definitely. So I think, in my view, regulation should be commensurate with the risk. So if there's a lower level of risk, there should be a lower level of regulation and vice versa. So I think what we currently focus on, and I'll just go a little bit broader than the FSCA and also speak to the work on the IFWG side and the KWG. From the FSCA side, I think the most anticipated change would be the Conduct of Financial Institutions Bill, as you know. And in terms of crypto assets, there's the possibility that that would increase the scope of activities that can be captured. Under that, and it obviously also repeals the FASE Act that's currently in place, and it caters for themed standards under that primary legislation. And that themed standards and the development thereof also provides an opportunity to look at those gaps, and I've mentioned the IMF and IOSCO and FSB, and to look where there needs to be bespoke requirements for specific type of risks that steps away just from the financial services risk and the current legislation that we've employed. Then on the IFWG and KWG side, certain priorities have been identified, and as you might know, stable coins is one of them, and then tokenization. So there's currently a lot of work being done on those two topics. So on the tokenization side, there's a primer paper that's being worked on and will be published when that's finalized, just setting out a bit of the landscape of tokenization and some initial ideas on risks and benefits. And then on the stablecoin side, there's already been a stablecoin paper diagnostic, also with the same purpose of really setting out the benefits and risks and what the local landscape looks like. So that's focused on rand-pegged stablecoins, as you might know. So we're currently busy with that second phase on the stablecoin work, and that would culminate in policy recommendations, looking at what would an appropriate framework look like specific to stable coins, and that would be consulted on. And then on the tokenization side, the next step is work under the Innovation Accelerator under the IFWG, and then also further analytical work that would also then culminate in policy recommendations that can be considered and consulted upon. So there's definitely work being progressed, I think, on those two topics for the reason that they're gaining traction. There's a lot of conversation, as we heard here today as well, and the ability to quickly be adopted by customers and grow quickly even to a financial stability risk as well. So that's the focus areas currently in the work that's being done.
it's encouraging to hear that, the scope of what's being addressed is very sort of aligned to what's important for the industry and I think what we need from a regulatory perspective. But Ashlin, what are the lessons do you think we can sort of take from a global perspective in terms of the development of policies and position papers going forward, and specifically in terms of that classification, which we talked about a little bit earlier?
I mean, I'm really glad to hear what Joe's saying about, the elements of stablecoin classification already being in the policy pipeline. And I think that's a trend we're seeing globally and have seen globally for some time as well. To borrow from Micah again, they have 3 buckets of classification that could be seen as what the robust view in the EU is. And that is, number 1, e-money tokens, number 2, asset reference tokens, and number 3, other. And the approach taken under that legislation is that if it behaves like money, we need to regulate it slightly differently. If it behaves like an asset reference token, we need to regulate it differently. And if it's an other, there's a different approach. And when it comes to other, the approach is very much to focus on disclosure, white papering, and providing as much information to market as possible. But I think the point on the first 2 classifications is that I think we have to acknowledge that stablecoins are becoming a massive volume taker in South Africa and on the African continent, as where a lot of activities happening in the crypto asset space. That being said, in South Africa currently, until the policy work is done, we don't have that as a classification. We kind of see all crypto assets under one banner, and the approach, I think, from at least a classification perspective, needs to be slightly different there. So that's one thing to mention. When it comes to non-stable coins, the other, I don't know if the micro approach makes sense. Essentially, getting white papering and having initial token offerings being a very robust process. I don't think we have the volume for that in South Africa yet. For that, I think the Liechtenstein approach makes much more sense, which is to treat crypto assets as wrappers, technical wrappers, and you look at the underlying nature of the relevant token to identify how to regulate it. So if it is referencing something very specific, then you regulate it in accordance with what that specific thing is, as opposed to creating a brand new regime for initial token offerings in South Africa. The other thing that I could say is, an observation that I thought was quite interesting is VARA out of Dubai has a soft rulebook mechanism when it comes to certain aspects of regulation, and that's worked incredibly well for them in terms of creating specific areas of regulation or definitions that are a little bit more nimble, that can be amended within the standards of a region, as opposed to being very, very heavy-handed, large-scale amendments. So the kind of stuff that belongs in guidance notes as opposed to regulation, so that you get the certainty into the market whilst not having too much of friction in actually rolling out changes as things develop. So those are just some of the observations that I'd mention from foreign countries that I think are relevant.
Yeah, I mean, it's very helpful to be able to sort of take that bird's eye view in terms of various jurisdictions and how we, the learnings that we can take. But I also think it's always very helpful to talk to players in the industry. And Dave, maybe you can talk to what it is that you would like to see regulatory certainty on, and where do you see the sort of future of the industry going, bearing in mind the sort of regulatory framework. What would be a best case scenario for you, again, from a regulatory perspective? If you could whisper in Joe's ear what you wanted for the future.
So I think there's a number of areas where we're looking for regulatory clarity. The first is really on taxation. So send off the message to SARS, so to speak. But SARS declared crypto assets a intangible asset, and that's all well and good. But how do you handle staking, DeFi yield farming, airdrops, certain NFT transactions? There's no clarity on how to handle these from a tax perspective. And what does that do? That just disencourages people from participating in that. It stops that part of the industry growing. So we're definitely looking for some clarity around that. The second is also taxation, but from a sort of capital nature. So at the moment, capital gains tax, you have to pay on every time you sell your crypto asset. Now, I can go around the corner with my hardware wallet and I can buy a pack of gum with a few Satoshis or a bit of Bitcoin on the Lightning Network. And that 10 Rand's worth of Bitcoin now is actually subject to me doing a capital gains tax calculation, right, and a declaration thereof. So these kind of micro purchases, every pack of gum, every cup of coffee that you might buy with crypto, or every blog that you decide to read and you pay a couple of sats or a little bit of a stable coin or something to, are subject to, you can understand it's just infeasible and unenforceable. So what we'd really like to see from that perspective is some sort of de minimis threshold, whereby after which you've spent a certain amount, maybe it's your normal capital gains allowance that you get every year, I think it's 40,000 Rand, but maybe after that, then you have to start doing capital gains tax calculations and declarations. But you could kill a whole arm of the industry by not permitting micropayments, by enforcing these types of calculations. So we'd definitely like to see some sort of movement or clarity provided from that perspective. The third and final one was, and I'm so happy Johann mentioned it, is stablecoins and tokenization. So, and it's not just sort of your domestically issued stable coins, but also your foreign issued stable coins. We are looking for some regulatory clarity on that perspective. So we eagerly await the publication of these papers to see where we land on that. And I know the FSCA in particular has been really good with engaging with industry around stable coins and asking, I mean, we've got a stable coin at AltcoinTrader. We've answered questionnaires, we've given feedback. So hopefully that all comes into something that's quite fit for purpose. Further than just sort of stablecoin tokenization, you've got tokenization of real-world assets. Now, that's obviously a hot topic at this perspective. So we definitely would like to see sort of further clarity on that from that perspective. Are we going to try and crowbar these sort of products and transactions into existing banking and securities legislation, or are we going to create a separate sort of more fit-for-purpose type of framework that can deal specifically with it? And that's what industry is waiting to find out. Best case scenario, again, is unrealistic. We look forward to a time, maybe, in the distant future where we can deregulate instead of regulating everything to the nth degree. It's working really well in Argentina at the moment, the sort of process of deregulating. I don't think we're there yet as a country, and I think the regulations are 100% necessary, and we fully back them. And I do understand the challenges that the regulators have in dealing with things like exchange control, where you can walk across the border, remember 24 words in your head, and you could have exported several billion rands worth of Bitcoin. All right, so I understand the challenges. But we do like the fact that the regulators are working with industry. For all intents and purposes, our voices are being heard. And maybe we will end up in a place where we've got as little regulation as possible to manage a fair industry that protects all stakeholders, especially the consumers.
Thanks. I am generally sort of supportive. I have one more question for, have we got time, Joe? No? Okay, I was keeping an eye on time. Joe, just on that point, I mean, when it comes to regulatory sandboxes that could potentially support in terms of some restraint on regulation that isn't necessarily required but is also fit for purpose, what's your view on that? Because it's a huge administrative and financial burden on regulators, and be interested to hear what the FSCA's approach is on that.
Look, I think for us, and I'm speaking of my own experience, the sandboxes have been integral and very useful for the regulators. I think the way we've designed it take away some of the burdens. We have a rolling application process, so it's not one specific time in the year that you can apply. So it manages that resource impact from that perspective. And also it's an interagency sandbox, which I think is quite unique and exciting if you look at some of the sandboxes across the globe. And because it's interagency, again, you have the opportunity to share those burdens, administrative burdens between the regulators, and have the correct participation in those sandboxes. So I think, besides the fact that it helps a safe space for innovation, it helps the regulators to understand the technology as well, and where the legislation could or should adapt and do not fit specifically for that use case. It also opens collaboration and conversations, and create trust in the process and transparency. So I think although, yes, it is quite administrative burden for the regulators, the way it's been developed and the way it's been used has been very successful, and a great opportunity for the regulators to learn and innovate with the industry as well.
Great, thank you. I felt fortunate to be able to get the insights from all of you today. For a tail end of a session, I think it was interesting and substantively important.
All right. Thank you so much to the panel. Thank you for those insights. We really appreciate it.
Thank you.